Joining me now, CNN legal analyst Shan Wu. He's former federal prosecutor and a defense attorney. And Shan, granting that as members, their committee, Schiff has been briefed on things that you and I have not seen, Mark Warner as well with the Senate Intel Committee. But based on what we know in public, do you think they're going too far here to say that there is clear evidence of wrongdoing by this president?
Yeah, it's really interesting. I was thinking about this, Jim, and I guess I want to preface my answer with the structure I've been thinking about with what they face versus what prosecutors face. So for a prosecutor, you first face a little bit of a more quantitative analysis. Is there probable cause? Does the evidence get to that basic level? So here I would say, if we put it in the political realm, I would agree that there could be probable cause for both the collusion, meaning some sort of communication for a conspiracy, as well as the obstruction. The next step for a prosecutor is the discretion aspect, and sometimes that's described as, do you have enough to prove it beyond a reasonable doubt? Yeah. Should you bring the case? And there, I think a prosecutor's discretion varies very widely from congressional because there are such different points. So I would say from a prosecutor's standpoint, I think there could be enough to charge in terms of probable cause for the collusion aspect.
Based on what? Based on what we know? Because, I mean, for instance, if you look at even Michael Cohen's testimony last week, he was somewhat vague on, he said there was a phone call, for instance, that the president knew and approved of the Trump Tower meeting in 2016, and that he got a heads up as well on WikiLeaks releases. But to our knowledge, and of course, Robert Mueller might have other substantiating evidence, we don't know, but to our knowledge, that's all Cohen had. I mean, what gives you the confidence as a prosecutor that there's enough there to establish probable cause?
It's the substantive aspect of the communications that went on. It's the idea that there was the exchange of the polling information, and it's the president's campaign manager doing that. And with the WikiLeaks, it's the evidence that there's this phone call going on. WikiLeaks, I think, is a little bit weaker because you're kind of really lacking that intermediary aspect. But for that, probable cause is not that high of a standard. For that type of minimum standard, I think you could have enough there. Yeah. But on the discretionary part, I think we would be a ways from making that decision. As a prosecutor, Congress is very different.
Yeah. I mean, it gets back to that Jim Comey speech relating to Hillary Clinton, right? I mean, he said, listen, she did a lot of bad stuff. I believe he called it reckless, but that a prosecutor most likely would not have proceeded to charge criminally here. But that's essentially the question, right? Is that this is, in the final analysis, it's likely to be a political judgment, is it not, for members of Congress, whether they proceed, particularly if Robert Mueller sticks with the DOJ guidance on indicting a sitting president?
Absolutely. It's very much of a political judgment, and I think what we're all trying to do is, given the rather limited precedent of presidential impeachments, we're all trying to apply some sort of a prosecutorial analysis, legal structure to looking at what they'll do. And I think when you look at the two aims of prosecutors versus Congress trying to bring in the light, bring things forward, I think that becomes a very interesting situation. On obstruction, though, I have to say, it seems a much stronger case to me. Almost every day the president is tweeting things which could be construed as trying to interfere with the investigation. So there, I'd say on the discretionary aspect, I would say they're much closer to that. Even as a prosecutor, I think you'd be more comfortable charging that because there are just so many instances of it, including, of course, two things particularly tantalizing. The Comey firing, and then also there's this issue of, it sounds now like President Trump's legal team may have did meet with Cohen prior to his original testimony, during which he lied. So that really raises the question of what happened there, and I think it transforms those lawyers into witnesses at this point.
We'll see. Jay Sekulow, of course, denied what Cohen said, but if there's proof, it's another issue. Shan Wu, thanks very much.
Thanks, Jim.